What's up? What's up? What's up? What's up? What's up? What's up? What's good, y'all? It's been a minute. It's been a minute. I got my glasses on like that's gonna help me see. It's not. Can y'all hear me? Tell me, put one in the chat if you can make so I can hear you. Hey, lovely lady. Let me see. I can see better without my glasses. Flotty Mangoes. What's up, Doug? Let me get my life together over here on Facebook. Let me see if I can get some folks to see. For some reason, every time I come on and I do a live on Facebook, the privacy settings goes to private. Like, what's the point of that? Well, what is the point of that? There is no point in that. All right, so I gotta come on here when I start seeing the fuck shit. I gotta come. Thank you, appreciate you telling me. Yeah, I gotta ask y'all to do that. I'm glad y'all can hear me. Because I spent about 40 minutes making a video for my students. Um, and when I went to play it, there was no audio. I was like, why is Mercury in retrograde? Is that what's happening? Okay. All right. So I'm doing this video because the Supreme Court issued a decision regarding the Alien Enemies Act, and I want to make sure that we understand what exactly happened because there is no journalistic integrity anymore in this country, and everything is clickbait and headlines and bullshit, but not really explaining what's happening, right? And so I want to be clear: the Supreme Court didn't decide shit. They all touting Trump gotta win, Trump gotta win, Trump didn't get shit. He did not get a win. He did not get a win. That's not the appropriate way for us to characterize what exactly happened. Now, if you've been following me for a minute, then you know about the shadow docket because I've spoken about it. You've either heard me talk about it here on YouTube, Facebook, or you heard me talk about it on Sirius, Urban View, channel 126. Catch me on Thursday mornings at 8 a.m. on the Talk to My Lawyer segment. But I've spoken about this so that you all can know. And it's like, I'm foreshadowing and giving you harbingers. But I told you that this shit was coming, right? So the shadow docket is where the Supreme Court handles emergency application. To distinguish that from the regular Supreme Court docket, which is what's known as the merits docket. The merits docket, where they actually brief cases. And when I say brief cases, I mean they submit legal briefs, memorandums of law that have arguments inside of them, right? I'm trying to say this as plainly as possible. Um, and then on top of those written arguments, the litigants come and they do oral arguments where they field questions from the court that may not be covered in their briefs, right? And then the court deliberates and they meet with their law secretaries and their legal people, and then they come up with a decision. That's not what the fuck happened. Now, this is the particular case with the young man whose last name is Garcia. And I believe that they were removed out of Texas. But I have the decision and I want to look at the decision. I just want to make sure that we understand what happened. So there was an injunction, right? So the lawyers for some of the migrants that were rounded up under the suspicion that they were gang members associated with the Trende, I'm going to say this wrong, Aragua, Trend, anyway. Y'all know what the hell I'm talking about. Mi gente, ayúdame, por favor. don't get me started. My Spanish is tight. It's a little tight. I've been slipping. I need me um, I need me a Spanish boyfriend so we could practice. Practique. All right. Y'all know I'll be going off on tangents, right? Okay. All right. So the district court said, you know what? Don't do that. You can't remove these people without due process. That's what the district court said. I said it right, Doug? Oh, thank you. District court said you can't do that, right? The district court did not decide whether or not the Trump administration had the authority to use the Alien Enemies Act, which is a whole different argument, right? That's a different argument as to whether or not the administration, which is using what is a wartime act, a wartime in a time where we are not at war, right? Whether or not those steps and elements have been met so that they are can use that. That's not what the district court is even decided. The district court just said, yo, injunction, stop. You can't send them off without due process, right? So the government was like, man, fuck that. I'm going to appeal right now. In the interim, when the district court was considering this, they were behind closed doors shuffling. When I say they, I mean the government, Homeland Security, Pam Bondi, Christy Nome, them, them. They were shuffling these migrants onto a plane, knowing that there was a court hearing that was about to determine whether or not the shit that they was doing was proper. So they did it. And then they played dumb at the hearing, like, we don't, you know, that's not in the record. We don't really know what's going on with the planes. We don't know. Meanwhile, they were sending people to El Salvador, right? Meanwhile, the plane landed with hundreds of migrants, many of whom are from Venezuela, many of whom may never have been, you know, associated with the gang, but certainly many of who are not familiar with El Salvador. Nonetheless, after the district court obviously said, stop doing that. This is an injunction. I mean, stop. That's to stop the government from doing a thing they're doing. The government appealed. The government appealed to the circuit court. Circuit court said, yeah, you can't do that shit. Stop fucking doing that. The government was like, man, fuck that. We got a majority in the Supreme Court. Let's go some more. So they appealed to the Supreme Court. And so the Supreme Court, on their shadow docket, issued a per curium opinion. Per curium means that it's just a majority from the court, and nobody signed this decision. Nobody was like, yeah, I'm going to author this fuck shit. Put my name on this bullshit. Nah, it was like, just say it's per curium, you know. That just means that most of us agree. It just means of the court. It's a decision of the court. But we know who's not with that fucking decision because we have actual dissenting opinions. Dissenting opinion. D just sounds so much more effective. Dissenting opinions, right? So we got a dissenting opinion from the liberal justices, and in part of the dissenting opinion from, I believe, Sotomayor or from Ketanji Brown Jackson. Your girl jumped in on that one. Amy Coney Barrett, she jumped in on part of the dissent. But then they were concurring. I think your boy Brett, I like beer, Kavanaugh, he wrote a concurrent opinion. And so basically what the Supreme Court said was, we're going to vacate the injunction, right? Because the court did not have the authority to issue the injunction. Procedurally, this case was not brought as a habeas petition, which is what it should have been brought as, right? The court said, you're in the wrong venue. You brought this case in the wrong venue. You have to bring a habeas petition in the venue where the people are being detained. And so they said, we're gonna vacate the injunction because it was improperly issued. They're not siding with fucking Trump. They just vacated the injunction. So that means that the government can continue to do what they were doing before, because they did not decide the merits of whether or not the government is properly using or improperly using the Alien Enemies Act. But here's the caveat. Here's what the Supreme Court did say that nobody is talking about. The Supreme Court said, but if you're going to do this fuck shit, you have to give them notice and an opportunity to be heard. You know what that's called? AKA due motherfucking process. It's called due process, right? Notice. It's not due process is not just I'm coming to court. Due process is notice. It's two things. It's two layers. It's notice. That's one. And an opportunity to be heard, meaning I get to go to court and contest what you say about me, that you say that my tattoo that is about autism awareness is about gang membership. I get to contest that, challenge that, right? And so that's the biggest takeaway, is that what the government was doing, they can no longer do. They were summarily removing people from this country without any process whatsoever. And nobody is reporting that. Listen, they don't want to give them fucking due process. You know what that means? That means that they have to go to court. You know what that means? That's a process. That's a process. That means that you don't get to just summarily remove people. They got to actually go to court. That's burdensome to the administration. They don't want to have to do that. That is not a win for them. That is a major fucking loss for them. That's a major loss for them. All right, so let's look at it. Y'all got any questions before I pull up this decision? Let's get into this decision. It's interesting because the actual per curium decision is only like a page and a half, right? It's like a page and a half, and they take the out because they're like, this procedurally is in the wrong place, procedurally. All right, so let's look at it. The problem I think I'm gonna have is I can't make this shit bigger. I did this before, and let me see one other thing. Because I think I'm sure ain't gonna be reading. Hey, bro. I see my little brother in the chizat. What's up, bro? Dad called yesterday. I told him you was just here. He said you was crazy. He was like, that's your brother. I was like, that's your son. Don't try to put him on me. I claim you, bro. You know I claim you. That's my little brother for real, like my biological little brother. We got the same parents and everything. Yep. 4 years younger than my brother. Okay, what was I doing? Why you distracting me, bro? All right, let me come back to this. I'm coming back, y'all. I'm coming back. I'm gonna see if I can bring this up a different way. Let's see if that is that bigger. I think that's bigger. So let's do it that way. Let me go up. Sorry. Watch your eyes. All right. Okay. Let me start over. I didn't move it though. Oh, it is moving. Okay. All right. So typically when a court renders a decision, they typically start with, a brief recitation of the facts. I just want to make sure that as I'm moving this, y'all. Yeah, it's moving. Go me. Thank you, Southern Breeze, for shouting out my little brother for real. I only got one. Yeah. All right, let's get into it. I told you what per curium already means. This matter concerns the detention and removal of Venezuelan nationals believed to be members of Tren de Aragua, TDA, an entity that the State Department has designated a foreign terrorist organization. That's one of the other things that that you can contest, right? So when they go to the merits of the Alien Enemies Act, they're gonna be dealing with all of these issues. The president issued this proclamation in invoking the Alien Enemies Act, right? To detain and remove Venezuelan nationals who are members of Tren de Aragua, invocation of the Alien Enemies Act regarding the invasion of the United States by Tren. That's another factor, right? When they do the merits, is there really an invasion, motherfuckers? Come on. Okay, 5 detainees and a putative class sought injunction and declaratory relief against the implementation of and their removal under the proclamation. Initially, the detainees sought relief in habeas, among other causes of action, but they dismissed their habeas claims. That was a mistake. They should not have dismissed their habeas claims, right? Because the court is basically saying that you have to move in habeas because that is the proper mechanism for this action. All right, so that's part of why they didn't decide it on the merits. On March 15, 2025, the District Court for the District of Columbia. So remember, these people were in Texas. They were housed in Texas, so the venue issue comes up. Initially, detainees sought relief in habeas among other causes of action. Oh, I read that already. Sorry. Okay. The District Court for the District of Columbia issued 2 temporary restraining orders preventing any removal of the named plaintiffs and preventing removal under the AEE of a provisionally certified class consisting of all non-citizens in U.S. custody who are subject to the proclamation. Minute order. That's just the reference of where you can find this. What the court is reciting. On March 28th, the district court extended the TROs for up to additional 14 days. The D.C. Circuit denied the government's emergency motion to stay the orders. Remember, I told you about the appeal. District court is where they start. Circuit court is the intermediate court of appeals. And then the highest court of our land is Supreme Court. So they're going through the stages. The D.C. Circuit said, nah, fuck that. No, okay. D.C. Circuit denied the government's emergency motion to stay the orders. The government then applied to this court, right? So the next place is is the court of last resort, which is the Supreme Court, seeking vacature of the orders. So they came to the Supreme Court to say, can you vacate the injunction? Because we want to keep doing the fuck shit we're doing. We construe the TROs as appealable injunctions. Sometimes temporary restraining orders are not reviewable, meaning they are not appealable. So these are. We grant the application and vacate the TROs. The detainees seek equitable relief against the implementation of the proclamation and against their removal under the AEE. They challenge the government's interpretation of the act and assert that they do not fall within the category of removable alien enemies. So they are challenging on the merits. But look what the court says. But we do not reach those arguments. Okay, so that's first. So this whole story that the Trump has won something is disingenuous, is intellectually dishonest because they haven't fucking reached the merits of that argument. All right, so we don't reach those arguments. Challenges to removal under AEA, a statute which largely precludes judicial review, largely, right? When it's done right, but it hadn't been done right, must be brought in habeas. So you heard me earlier, they dismissed their habeas. So if you're challenging the AEE, say that shit fast, twice, 3 times. If you're challenging the AEA, you must do it via habeas. This is their out, right? This is their out. Oh, we don't got to do it because procedurally, but they could, in the interest of justice, decide this shit. They could. Right? They get to decide when they exercise judicial restraint. Motherfuckers. Let me turn my mic down. I feel like I'm yelling at myself. Holding a habeas was the only cause of action available to challenge deportation of immigration statutes that precluded judicial intervention beyond what's necessary to vindicate due process right. So they're just citing why due process is the proper mechanism, regardless of whether the detainees formally request release from confinement, because their claims for relief never necessarily imply the invalidity of their confinement and removal under AE. Their claims fall within the core of the writ of habeas corpus. It must be brought in habeas. Again, they're just saying we can't decide this shit because procedurally you ain't bringing it right. Okay. Moving on. I gotta use my mouse because y'all know I'm blind. And immediate physical release, said that already. For core habeas petition, jurisdiction lies in only one jurisdiction. That is the District of Confinement. So that is why I initially started, I prefaced this with that these people, these migrants are being detained in Texas. The detainees are confined in Texas. Oh, it's like I'm a fucking psychic. So venue is improper in the District of Columbia. All right, venue is improper, which is where the case was brought. Remember, it started out in the district court in the District of Columbia. As a result, the government is likely to succeed. They're going to succeed on the merits because you brought this case in the wrong place. They're not merits of the action, right? They're going to see succeed on the merits of the injunction because you brought it in the wrong place. The detainees also sought equitable relief against summary removal. Now, this is where the Trump administration loses. Although judicial review under AEA is limited, we have held that an individual subject to detention and removal under that statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, as well as whether he or she is in fact an alien enemy, 14 years of age or older. That is what the proclamation said, right? Venezuelans 14 years of age or older. That's who we're targeting. Children. Children. Under the proclamation, the term alien enemy is defined to include all Venezuelan citizens 14 years of age or older who are members of TDA, are within the United States, and are not actually naturalized or lawful permanent residents of the United States. And that's the bullshit, because they are taking away naturalizations and green cards so that you could qualify to be removed. This shit right here. The shit that they're doing right now. Wait till I show you this part, though, because the point of this is to show you that we are on a very slippery slope. And if you are feeling comfortable because for some reason you think that you are a citizen of the United States so you can't be subject to removal proceedings, I have news for you, man. I have news for you. Okay, because they come for them first, and then they come for you. Then they come for us. It is well established that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. What that means? What does that mean? That means that they're entitled to due process. Okay? Aliens being foreign people to our country. That's what aliens, not extraterrestrials. Okay, although I don't know if maybe one day it will actually be an alien. So the detainees are entitled to notice and an opportunity to be heard appropriate to the nature of the case. That is due process. More specifically in this context, AEA detainees must receive notice after the date of this order that they are subject to removal under the act. The notice must be afforded within a reasonable time and in such a manner as will allow them to actually seek habeas relief in the proper venue before such removal occurs. That is not a win for the Trump administration. They don't want that. They don't want to have to go to court. They're trying to remove hundreds of people. Each person gets a hearing. Do you know how long that process now is going to take? That's not what they want. That's not a win for them. For all of the rhetoric, the dissents today's for all the rhetoric of the dissents, today's order and per curium confirm that the detainees subject to removal orders under the AEA are entitled to notice and an opportunity to challenge their removal. The only question is which court will resolve that challenge. For the reasons set forth, we hold that venue lies in the district of confinement. The dissents would have the court delay resolving that issue, requiring, given our decision today, that the process begin anew down the road. We see no benefit in such wasteful delay. The application to vacate the orders of the United States District Court for the District of Columbia presented to the Chief Justice of and by him referred to the court is granted. The March 15, 2025 minute orders granting a temporary restraining order and March 28th, the other restraining order for the District Court of Columbia are vacated. It is so ordered. And nobody signed this shit, you cowards. Why you didn't sign the decision? Why you didn't sign it? But that's not uncommon for shadow docket case, decision. So what was that? All of 1, 2, 3, 4, 3.5 pages. 3.5 page decision. Okay. So that was the decision. Justice I like beer is concurrent. I agree. I don't give a fuck about what he agrees with. Okay. Because I just don't. And he really is just saying, I agree that habeas is the appropriate vehicle. So I'm going to duck out on this and not decide the case on the merits because, we don't have to do that right now. But when y'all bring your habeas petition back, that's when we'll deal with it. All right. So now we got Sotomayor, Kagan joins, Jackson joins, and Justice Barrett joins to some of the parts, not all of the parts. Now, what I like about the dissent is that so this is a 25-page decision. We are only on page 7. So the dissent is for the rest of this decision, right? And so it's some really, really scathing things in here. that particularly we should discuss. So Sotomayor says 3 weeks ago, the federal government started sending scores of Venezuelan immigrants detained in the United States to a foreign prison in El Salvador. It did so without any due process of law under the auspices of the Alien Enemies Act, a 1798 law designed for times of war. Between the start of these removals, and this is great because it gives both the dissents, both of these dissents give us a full understanding of factually what happened and how the law interplays with those facts. It did so without any due process. Between the start of these removals and now, a district court has been expeditiously, and that was Judge Brosberg, expeditiously considering the legal claims of a group of detainees hereinafter plaintiffs who allege that their summary removal violates the Constitution and multiple statutes. The district court ordered a pause. That's granting the injunction. A pause on plaintiff's removal until it can consider their motions for a preliminary injunction at a hearing tomorrow on April 8th. Guys, that's today. That's today. There's a hearing today. Still, a majority of the court sees fit to speak on this issue today. They didn't need to. Critically, even the majority today agrees that the federal government now admits that individuals subject to removal under the Alien Enemies Act are entitled to adequate notice and judicial review before they can be removed. That should have been the end of the matter. Yet, with bare bones briefing, no arguments, and scarce time for reflection, break it down, because this is the shadow docket, right? The merits docket is where they have the briefing and the argument and time for reflection. The court announces that legal challenges to an individual's removal under the Alien Enemies Act must be brought in habeas petitions in the district where they are detained. The court's legal conclusion is suspect. Y'all sus! You want Sotomayor from the Bronx. Yeah. Okay, y'all know I'm a fan of the law, so yeah, I get excited about shit like this. Let me have it. I am. I'm a nerd. I'm a legal nerd. I'm a whole legal nerd. The court intervenes anyway, granting the government extraordinary relief. Injunctions are an extraordinary relief, guys. Extraordinary relief and vacating the district court's order on the basis alone. It does so without mention of the grave harm plaintiffs will face if they are erroneously removed to El Salvador or regard for the government's attempt to subvert the judicial process throughout this litigation. They didn't even mention that y'all playing hard to hand, y'all playing fast and loose. Y'all not doing shit that comports with the traditional notions of fair play and substantial justice. All right, because the court should not reward the government's effort to erode the rule of law with discretionary equitable relief, I respectfully dissent. This case arises out of the president's unprecedented peacetime invocation of a wartime law known as the Alien Enemies Act. Enacted in 1798 by Congress consumed with fear of war with France, the Alien Enemies Act provided a wartime counterpart to the widely denounced Alien Friends Act, which granted the president sweeping power to detain and expel any non-citizen he deemed dangerous to the peace and safety of the United States. Hold on, let me lose my place. Sorry. Y'all bear with me. Unlike the Alien Friends Act, which lapsed in disrepute as James Madison deemed it a monster that must forever disgrace its parents, the founders saw the Alien Enemies Act as a constitutional exercise of Congress's power to declare war, to raise and support armies, and to provide for calling forth the militia to suppress insurrections and repel invasions. I don't know a lot about the Enemies Friends Act. To that end, the act grants the president power to detain and remove foreign citizens of a hostile nation or government when there is a declared war with such nation or when a foreign nation threatens invasion or predatory incursion against the territory of the United States. I don't know that Venezuela is doing any of this. I don't know that Venezuela is a hostile nation or government. I don't know that we've declared war on Venezuela. I'm almost sure that we haven't. I'm not sure that it's a foreign nation that threatens invasion. I'm not sure Venezuela meets the standard for predatory incursion. Like, none of that fucking shit is a thing right now. It's all pretextual. that this government has decided that Venezuela, because listen, if they could do it for Venezuela, they could do it for where you from, right? They could do it for Jamaica. They could do it for Brazil. They could do it for any nation that they so deem is hostile, right? They could do it for anyone, right? And they could cancel your naturalization. They could cancel your green card. Your citizenship is not guaranteed. Yeah, that's why they're trying to get rid of birthright citizenship. Y'all better pay attention, baby. Pay attention. That's why I'm doing this. Okay. Well, I left off because I gotta talk. Before today, U.S. presidents have invoked the Alien Enemies Act only 3 times, each in the context of an ongoing war: the War of 1812, World War I, and World War II. And let me just say, when they did it in World War II, it later that case was known as Korematsu. Later, one of the worst decisions, along with like Dred Scott, one of the worst decisions that the U.S. Supreme Court has ever authored, ever. It is a blemish and a stain on our judicial memory. All right. That changed on March 14, 2025, when President Trump invoked the Alien Enemies Act to address an alleged invasion of the United States by Tren de Aragua, a criminal organization based in Venezuela. That's just a site. There is, of course, no ongoing war between the United States and Venezuela, nor is Tren de Aragua itself a foreign nation. The president's proclamation nonetheless asserts that Tren de Aragua is undertaking hostile action and conducting irregular warfare against the territory of the United States, both directly and at the direction of the Maduro regime in Venezuela. They don't have no proof of that shit. They don't have no proof of that. They really don't. So how are they going to establish that when this is actually addressed, the merits of the use of the AEA? How are they going to establish that? Based on these findings, the proclamation declares that all Venezuelan citizens 14 years of age or older who are members of Tren de Aragua and are not naturalized citizens or lawful permanent residents are liable to immediate apprehension, detention, and removal as alien enemies. And so don't get comfortable, right? If you think, oh, that doesn't apply to me, I'm a Venezuelan citizen, I'm 15 years old, and I have my naturalization papers. Okay, well, they can take them away. And now it applies to you. Because then you no longer have naturalization. Okay? It applies to you. Anything that they gave you, they can take away. Yep, that's right. I fucking said it. Congress requires the president to make public proclamation. Oh, and this is the other part, right? They didn't do this shit publicly. This is what I love about Sotomayor. She's dragging them in this decision. In this dissent, Congress requires the president to make public proclamation of his intention to invoke the Alien Enemies Act. President Trump did just the opposite, and what can be understood only as a covert preparation to skirt both the requirements of the act and the Constitution's guarantee of due process. The Department of Homeland Security began moving Venezuelan migrants from Immigration and Customs Enforcement detention centers across the country to the El Valle detention facility in South Texas before the president had even signed that shit. Ain't that some shit? Y'all already knew what it was before he even signed it, and you knew he had to make it public, so you got the pieces in position so that when the signing happened, there'd be no time for anybody to file anything. The transferred detainees, most of whom did not past or present affiliation with any gang, did not know the reason for their transfer until the evening of Friday, March 14th, when they were apparently pulled from their cells and told that they would be deported the next day to an unknown destination. Just stop for a second. Can you imagine? Can you fucking imagine? One day you just going about your business, you get fucking kidnapped by the United States government. They throw you in a cell, pull you out, throw you on a plane, and put you in one of the worst humanitarian prisons. I want to say humanitarian. It lacks any type of humanitarian oversight. One of the worst prisons in the country, in the world. Oh my God. I can't imagine. Like these are not people. You know what I mean? Like they don't have families. We know that some of them were improperly transported to this prison. And you know what? The government even now acknowledging that some of them were uh, let's say deported by administrative error. These fucktards say there's really nothing we can do about it now because we don't have authority over the Salvadorian government. What the fuck are you talking about? Y'all paid them $6 million to take these motherfuckers. What the fuck are you talking about? You can't call them up and be like, yo, we need that one back. Stop. The fuck, man? Suspecting that the president had covertly signed a proclamation invoking the Alien Enemies Act, several lawyers anticipated their client's imminent deportation and filed a putative class action in the District of Columbia. They fucked up on that because their clients was in Texas. They should have filed that shit in Texas. But listen, the fact that they filed anything at all, because they really didn't have any information because this shit was done secretly, right? So they were just acting off probably a phone call from one of their clients who got wrapped up, like, yo, they just picked me up, ICE got me, and da 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 da. And so, they're filing blind applications, just to get it before a court. They contest the Tren de Aragua had committed or attempted to the kind of invasion or predatory incursion required to invoke the AEA. They also asserted that it would violate the due process clause to deport their aliens before their clients, before they had any chance to challenge the government's allegation of gang membership. The plaintiffs did not seek release from custody, but asked the court only to restrain the government's planned deportation under the proclamation. And that's probably why they dismissed the habeas, because they weren't seeking release. And they probably misunderstood that to mean that, okay, since we're not seeking release, that habeas is not the proper mechanism. And now they're learning that it was. In the early morning of March 15, the district court informed the government of the lawsuit and scheduled an emergency hearing despite knowing of plaintiffs' claim that it would be unlawful to remove them under the proclamation. The government ushered the named plaintiffs onto planes along with dozens of other detainees, all without an opportunity to contact their lawyers, much less notice or opportunity to be heard. Basically, without any due process. The government's plan, it appeared, was to rush plaintiffs out of the country before a court could decide whether the president's invocation of the AEA was lawful. That's fucked up. Or whether these individuals were, in fact, members of Tren de Aragua. That's fucked up. They know what they were doing. They knew what they were doing. I'm sorry, Mom. I don't know why this keeps happening, but that is so fucked up. They knew what they was doing. Okay. The government's plan, did I say that already? Was to rush plaintiffs out of the country before the court. I heard that already. Plaintiff, this is Garcia, I believe, JGG, for example, had no chance to tell a court that the tattoos causing DHS to suspect him of gang membership were unrelated to a gang. He avers that he is a tattoo artist who got an eye tattoo because he saw it on Google and thought it looked cool. Plaintiff GFF, too, was denied the chance to inform a court that the government accused him of being an associate affiliate of Tren de Aragua based solely on his presence at a party of strangers, which he attended at the insistence of a friend. Like, how the fuck y'all even know about that? Like, are y'all surveilling, parties of Venezuelans? How, where's that come from? Recognizing the emergency the government had created by deporting plaintiffs without due process, the district court issued a temporary restraining order that same morning. The order prohibited the government from removing the 5 named plaintiffs, including JGG and GFF, pending ongoing litigation. GFF, who had been on a plane for about 40 minutes to an hour, as crying and frightened individuals were forced on board, was subsequently retrieved from the plane by a guard who told him, "You just won the lottery." Told him he just won the lottery. Why? I won the lottery because y'all not gonna fucking violate my rights? The court then set an emergency hearing for 5 p.m. that same day, at which it planned to consider plaintiffs' claims that temporary relief should be extended to a class of all non-citizens subject to the anticipated proclamation. The anticipated still hadn't been out. The proclamation still's not out. Despite notice to the government of the court scheduled hearing, DHS continued to load up the 2 planes with detainees and scheduled their immediate departure. They was like, fuck that. Keep doing what you're doing. The government, in this parenthetical for this cite to the transcripts at page 9 from April 3rd, the government counsel agreeing that DHS was acting in preparation of the proclamation before it was posted. Y'all nasty. That's ugly. That is so ugly. Oh my God. Okay. Not until an hour before the district court scheduled hearing and only moments before the government planned to send its planes off to El Salvador did the White House finally publish the proclamation on its website. At the 5 p.m. hearing, the district court provisionally certified a class of Venezuelan non-citizens subject to the proclamation. It then issued an oral temporary restraining order prohibiting the government from removing all members of the class pursuant to the proclamation for 4 days. Do you know the government said, oh, that don't count because you said it from the bench? Like, what the fuck, man? The order did not disturb the government's ability to apprehend or detain individuals pursuant to the proclamation or its authority to deport any individual under the Immigration and Naturalization Act. All it required of the government was a pause in deportation pursuant to the proclamation until the court had a chance to review the legality. It didn't say you could never do this. It just said, hold up. Let's look at this shit, make sure it's all gravy. But the government, y'all knew this shit. This is when you consciousness of guilt, when you know that you're doing something wrong. You don't want to wait. You don't want to abide by the pause. You don't want anyone to pull back the covers and look and see exactly what you're doing. So you're like, just keep going. Keep going before they catch us. Now, if Bondi wasn't in bed with DHS, then there actually might be a federal government like who investigates this, the Department of Justice, maybe the Attorney General will look into this and see if anything had been done, illegally. But we don't have that. We don't have that. The court further directed that any plane containing individuals subject to the proclamation that is going to take off or is in the air needs to be turned around to the United States. Y'all know what happened with that, right? It was like, man, we can't do that. Concerns about the government's compliance with the order quickly followed. Even now, the district court continues to investigate what happened via show cause proceeding. Show cause are emergency applications, emergency motions, right? Come show me what the fuck happened. In those proceedings, the government took the position that it had no legal obligation to obey the district court's orders directing the return of the planes in flight because they were issued from the bench. You know how many orders come from the bench? More orders come from the bench than are written. So we could just ignore the ones from the bench? Let me know, because I'm just trying to figure something out. I'm asking for a whole lot of motherfucking clients. Government. Is that the standard that the government wants to set, that people could just start ignoring court orders because it was issued from the bench? The fuck? We are a nation of laws. We are a nation of laws. We are a nation. I'm gonna keep saying that because we really are challenging that concept. I mean, seriously. Of course, as the government well knows, courts routinely issue rulings from the bench, and those rulings can be appealed, including this, to the court in appropriate circumstances. The district court, for its part, has surmised that the government knew as of 10 a.m. on March 15 that the court would hold a hearing later that day. Yet it hustled people. It hustled people onto those planes in hopes of evading an injunction or perhaps preventing individuals from requesting the habeas hearing to which the government now acknowledges they are entitled. Y'all knew. All along, y'all knew they were entitled to due process. It's unacceptable that you now come to heel. It's unacceptable that you now, after you have already caused such disruption, that you now say, yeah, you know what, my bad, you was right. They should have got a hearing. That's true. That's on us. Like, whoa, what the fuck, man? Like, yo. Rather than turn around the planes that were in the air When the court issued its order, moreover, the federal government landed the planes full of alleged Venezuelan nationals in El Salvador and transferred them directly into El Salvador Center for Terrorism Confinement. Deportation directly into CCOT presented a risk of extraordinary harm to these plaintiffs. They don't give a fuck. The record reflects that inmates in Salvadoran prisons are highly likely to face immediate and intentional life-threatening harm at the hands of state actors. CCOT detainees are frequently denied communication with their relatives and lawyers and only appear before courts in online hearings, often in groups of several hundred detainees at the same time. El Salvador has boasted that inmates in CCOT will never leave, and plaintiffs present evidence that inmates are rarely allowed to leave their cells, have no regular access to drinking water or adequate food, sleep standing up because of overcrowding, and are held in cells where they do not see sunlight for days. This is some crazy shit. One scholar attests that an estimated 375 detainees have died in Salvadoran prisons since March 2022. What if the government later determines that it sent one of these detainees to CCOT in error? This is Sotomore. She's being facetious, all right, a little bit, because this shit happened. Ain't no what if. Or a court eventually decides that the president lacked authority under the Alien Enemies Act to declare that Tren de Aragua is perpetrating or attempting an invasion against the territory of the United States. The government takes the position that even when it makes a mistake, it cannot retrieve individuals from the Salvadorian prisons to which it has sent them. The fuck? Listen. The government takes the position. Oh, I said that already. I'm fucking pissed off. The implication of the government's position is that not only, oh, here's the part, y'all. This is the part. This is the part I want you to see. The implication of the government's position is that not only non-citizens, but also you watching this right now, you United States citizen, you could be taken off the streets, forced onto planes, and confined to foreign prisons with no opportunity for redress if judicial review is denied unlawfully before removal. History is no stranger to such lawless regimes, but this nation's system of law is designed to prevent it, not enable their rise. That's powerful. That's foreshadowing. That's the foreshadowing I'm talking about. That Sotomayor is trying to warn you. She's trying to warn you. Let me come back. Let me see. I'm missing some notes. Let me take a break for a second. Going to court will eliminate actual citizens from getting swept up in. No. Going to court is not going to eliminate shit for actual citizens. Y'all don't have no protection. We don't have any protections. Allegedly, Venezuela released their prisoners and sent them to the border. I haven't found a credible source to support it. I haven't seen that. That's crazy. Shitler will continue to ignore this. I don't know what that means, Otis. All right. Let me get back to it. We getting there, guys. We getting there. This is crazy. Sotomayor is giving us the harbinger right there. Because you all know the 13th Amendment. Do I have to tell you, once you are convicted of a crime, you're a slave. You can be enslaved. You can be committed to indentured servitude. And so you too, okay, can be shipped off. Y'all think I'm bullshitting. I can't be more serious about this. Even as the government has continued to litigate, back to the case, whether its March 15 deportations complied with the district court's order, it simultaneously sought permission to resume summary deportations under the proclamation. The district court first denied the government's motion to vacate its temporary restraining order, rejecting the assertion that the president's authority and discretion under the Alien Enemies Act is not proper subject for judicial scrutiny. At the very least, the district court concluded the plaintiffs were likely to succeed on their claim that before they may be deported, they are entitled to individualized hearings to determine whether the act applies to them at all. They do. They will succeed, just not in this court. That's what the Supreme Court is saying, that the government will succeed because y'all in the wrong goddamn court. It is only this court that sees reason to vacate for the second time this week a temporary restraining order standing on its last legs. Not content to wait until tomorrow, which is today, when the district court will have a chance to consider the full preliminary injunction briefing at a scheduled hearing. This court intervenes to relieve the government of its obligations under the order. So we could be right back here, depending on what the court decides, or depending on what they file. Okay, begin with that upon which all 9 members of this court agree. The court's order today dictates in no uncertain terms that individuals subject to detention and removal under the AEA entitled to judicial review as to questions of interpretation and constitutionality of the act, as well as whether he or she is in fact an alien enemy 14 years of age or older. So everyone, all 9 justices agree that due process is required. Okay. Therefore, under today's order, courts below will probe, among other things, the meaning of an invasion or predatory inclusion, and ask, for example, whether any given individual is in fact a member of Tren de Aragua. Even the government has now largely conceded the point. They're going to lose this shit. So too do we all agree with the per curium's command that the Fifth Amendment requires the government to afford plaintiffs notice after the date of this order that they are subject to removal under the act within reasonable time and in such a manner as will allow them to actually seek habeas relief in the proper venue before such removal. That means, of course, that the government cannot usher any detainees, including plaintiffs, onto planes in a shroud of secrecy, as it did on March 15. You know, they could start playing fast and loose again. They just start moving them around, right? So if I'm a lawyer and I file your habeas in Texas and then they fucking move you to, another detention facility in, let's say, Louisiana, then my habeas petition is moot because that's not the proper venue. So I go to Louisiana and I file that shit in Louisiana and then they move you again. Like this, that could be the next thing. You know what I mean? I don't put anything past these people. I really don't. In light of this agreement, the court's decision to intervene in this litigation is inexplicable as it is dangerous. Recall that when the district court issues a temporary restraining order on March 15th, the government was engaged in a covert operation to deport dozens of immigrants without notice or an opportunity for hearings. The court's ruling today means that those deportations violated the due process clause. The due process clauses, most fundamental protection. Yes, that is that. So does that mean that they now have a cause of action against the United States government? Because I think that these families should all sue the government. They should sue the government for this improper removal, for constitutional violations. You violated, the Supreme Court just said you violated my fucking constitutional rights. Well, I need some redress. How much is that worth? How much is it worth to each of these Venezuelan migrants who had to suffer? Right? Who's gonna pay that? Right? Who's gonna pay if they were to receive? Who paid when the Japanese were the victims of this Alien Enemies Act during World War II? Who paid then? Yes, the people paid. The people paid them when they got their reparations, because they did. Look it up. Look it up. Yes, they did. They did. I'm not saying it was, let's say, commensurate with the harm. I'm not suggesting that, right? But they got something. They got something. And the Venezuelans, they're going to be on deck to get something too. They're going to be on deck to get something too. The court's ruling today. Okay, I said that already. I'm sorry, y'all. The district court rightly intervened to prohibit temporarily the government from deporting more individuals in this manner based on its current assessment that the plaintiffs were likely entitled to more process. Against the backdrop of the U.S. government's unprecedented deportation of dozens of immigrants to a foreign prison without due process, a majority of this court sees fit to vacate the district court's order. The reason, apparently, is that the majority thinks plaintiffs' claims should have been styled as habeas corpus actions and filed in the districts of their detention. In reaching that result, the majority flouts well-established limits on its jurisdiction, creates new law on the emergency docket, and elides the serious threats our intervention poses to the lives of individual detainees. As an initial matter, the court lacks jurisdiction to review the district court's time-limited interlocutory order. It is well established that generally temporary restraining orders are not appealable, right? Generally. That rule is a general one because it gives way where a temporary restraining order risks imposing such an irreparable consequence that an immediate appeal is necessary if the order is to be effectually challenged. So sometimes they are appealable. Here, the district court ordered a 14-day halt on deportations pursuant to the proclamation because it thought that the plaintiffs were likely entitled to individualized hearings to determine whether the act applies to them at all. The government now admits that it must provide detainees with adequate notice, and it says that they can then file habeas petitions in the Southern District of Texas to contest and stay their removal under the AEA. Such proceedings, if adequately provided, necessarily mean that the government cannot imminently deport the plaintiffs under the proclamation. So it is hard to see why the district court's temporary restraining order, of which only 5 days now remain, presented the government with an emergency of any kind, much less one that required an immediate appeal. So what she's saying is, in order for you to get an injunction, you have to allege that if the courts do not intervene, there's some irreparable harm is going to take place. And Sotomayor is saying there's no irreparable harm because the government is now agreeing that you have to give them a hearing. And so there's no emergency. There's no emergency because you are not allowed to just summarily remove people without due process. And since you concede that point, then you also concede that you don't fucking have any standing to be before this court on an emergency application. Also troubling in this court's decision to vacate summarily the district court's order on the novel ground that an individual's challenge to his removal under the AEA falls within the core of the writ of habeas corpus and must therefore be filed where the plaintiffs are detained. The court reaches that conclusion without oral argument or the benefit of percolation. Hey, you ain't let it percolate. You ain't let it percolate. Come on, you can't read percolation and not think about the song. Now I'm not gonna get that song on my head. You ready for the percolator? Get ready for the percolator. Okay. Or the benefit of percolation in the lower courts, and with just a few days of deliberation based on bare bones briefings. The conclusion is dubious. She already said it was sus. Now it's dubious. As an initial matter, let me make sure this is still Sotomayor, right? We didn't get to Jackson. Yeah, sure. I just want to make sure I'm not skipping. Also troubling is the court's decision making. It's dubious, she said. This conclusion is dubious. As an initial matter, the majority's assertion that plaintiffs' claim sound in habeas is in tension with this court's understanding of habeas corpus as its core and avenue for a person in custody to attack the legality of that custody and to secure release from illegal custody. Hold on, I gotta find my mouse. And to secure release from that illegal custody, the plaintiffs in this case sued not to challenge their detention, but to protect themselves from summary deportation pursuant to the proclamation. Indeed, because all of the plaintiffs were already in immigration detention under other statutes when the government subjected them to the proclamation, they have repeatedly emphasized throughout this litigation that they do not seek release from custody and are not contesting the validity of their confinement or seeking to shorten its duration. So, guys, some of these people are in detention based on the Immigration and Naturalization Act, right, which is separate and apart from the Aliens Enemies Act. So they would not have had proper bearing or proper legal footing to seek release, right? Using habeas corpus because they had been detained on other grounds. But I disagree. I think that oftentimes you can have a order of commitment, meaning that is the mechanism that keeps you in prison. You can have more than one. You can have more than one order of commitment, just like if you had more than one case, right? You could have two bail settings, right? So you could theoretically be out, right? You could be released on one case, but you could be in on another case, right? And so how they calculate your time and things of that nature is affected by that particular circumstance, right? So if you, let's say you were out you were released on your own recognizance and you caught a new charge, and then the judge set bail on your new case. Well, you would ask the court to set bail on your old case so that you could get credit for the time, right? Unless you knew you were making bail on your second case, right? On your new case. If you knew you were making bail on your new case, you don't want the court to set bail on your first case, because now you got to make two bails, right? They could have two commitment orders, right? And so the habeas could have been with respect to the commitment order under the AEA. And so they could have sought to be released from that sort of confinement in a way. It's an artful sort of way to go about a habeas petition. But fuck that, man. You got to get legally artful with these motherfuckers. You got to do it. You got to do it. You got to do it. I got to take my legal brilliance somewhere beside the classroom. I'm trying to make other brilliant lawyers. You know, that's why I am a professor. That's why I love teaching. And I love being able to teach the new lawyers that are coming up, right? And trying to pour some of the passion that I have inside of me for the law in its ability to change and transform policy, right? And subsequently life. But at the same time, I recognize that, you know, sometimes I need to be part of some of this shit. Anyway, all right. That's why I'm doing this. Okay. Because that's an interesting little caveat. I wanted to make sure that I explained it a little bit. I hope I did. I hope I'm explaining it, you know, in a way that is palatable for you all. Nevertheless, the majority insists the plaintiff's claims necessarily imply the invalidity of their confinement and removal of the act, and so essentially amount to a challenge to their present physical confinement. So there's a misunderstanding about what exactly the plaintiffs are seeking, right? And so Sotomayor is trying to clarify it. It therefore analogizes this case to the line of cases beginning with Heck v. Humphrey, where the court held that individuals serving state criminal sentences cannot bring 1983 suits to complain of unconstitutional treatment at the hands of state officials, if a judgment in their favor would necessarily imply the validity of his conviction or sentence. In such cases, that's so not the fucking case here. In such cases, habeas is the exclusive avenue for relief. Plaintiffs' claim, however, do not imply. And so that's what they're saying. They're like, listen, when someone is in state custody and they want to bring in action, the Heck v. Humphrey says the individual serving state criminal sentence, you can't bring a 1983 suit if it would, in fact, nullify your conviction, right? Because obviously that makes sense. So you're a murderer, and let's say that the corrections officers mistreat you, and you want to bring some sort of civil action. And so if you bring a civil action under a habeas and it's granted, then they say you should be released from your murder sentencing, from your confinement on the murder. No, that's not what the fuck. That's not how the fuck that's supposed to. That's not how the fuck that's supposed to work. Fuck out of here. In such cases, habeas is the exclusive avenue for the plaintiff's claim, however, do not imply the invalidity of their detention, because their detention predated the proclamation and was unrelated to the Alien Enemies Act. Again, so some of their detention is based on just regular old ICE proceedings, Naturalization and Immigration Act shit. This, if they succeeded in showing that they could not be removed under the proclamation, they would not result in their release from detention. Even in the context of 1983 challenges by criminal defendants, this court has never recognized habeas as the sole remedy or even an available one, where the release sought would neither terminate custody, accelerate the future date of release from custody, nor reduce the level of custody. So Sotomayor is saying that's not the only fucking remedy. Y'all bullshitting. It's not the only remedy. Habeas is not the only remedy, especially because they don't seek release. There's also good reason to doubt that Heck's holding about the availability of relief under 1983 extends to Administrative Procedures Act. That's what this was brought under. It wasn't brought under the habeas. It was brought under the Administrative Procedures Act. Claims challenging executive actions under the Alien Enemies Act. The Heck bar arose from the court reading an implicit exception into 1983 to avoid swapping the habeas statute's coverage of claims that the prisoner is in custody in violation of the Constitution. This court has never limited the availability of the APA release so narrowly. To the contrary, the APA has long been available to plaintiffs absent specific preclusion by Congress. So they're saying they could. This is appropriate for them to bring this action under the Administrative Procedures Act. They don't have to bring it under a habeas. Y'all bullshit, and that's why it's dubious what y'all saying. That's why it's sus. That's why it's suspect. All right. Although the APA allows courts to review only agency action for which there is no other adequate remedy in the court, this court has long read that limitation narrowly is emphasizing that it should not be construed to defeat the central purpose of providing a broad spectrum of judicial review and agency action. I want to get to Ketanji and see if she wrote something separate. I think she did. So this is all just talk about the habeas. This is still sort of, let me just see something. It might just be that they all just joined in on her dissent and that there is not a separate dissent. Let me just make sure. Nope, there is a separate dissent, Jackson. Okay, I'm just going to fast forward a little bit because I want to read a little bit of the Ketanji Brown Jackson's dissent. Let me just check and make sure. When I'm reading this, I can't see y'all. Let's see if there's any questions. Okay. No questions. All right. All right. All right. Let me get back to it. I love she. Yes, I'm biased. Judge Jackson dissented. I joined Justice Sotomayor's dissent in full and would deny the application for all the reasons she explains. I write separately to question the majority's choice to intervene on the eve of the district court's preliminary injunction hearing without scheduling argument or receiving merits briefing. This fly-by-night approach to the work of the Supreme Court is not only misguided, it is also dangerous. Let's go! Yo. All right. I'm too excited about this. I know. I'm sorry. Leave me alone. Okay. I'm a lawyer. I'm a New York lawyer. Yes, I is. All right. The president of the United States has invoked a centuries-old wartime statute to whisk people away to a notorious. Hold on. That's funny. She's funny. Cause it's kidnapping. They ain't whisking nobody. This is motherfucking all-out kidnap, Judge Jackson. I mean, I know you're trying to be judicious and democratic and shit in the way you word shit, but this is an all-out kidnapping. Okay, sorry. Statute to whisk people away to a notoriously brutal foreign-run prison. For lovers of liberty, this should be quite concerning. Surely, the question whether such government actions is inconsistent with our Constitution and laws warrants considerable thought and attention from the judiciary. This was why the district court issued a temporary restraining order to prevent immediate harm to the targeted individuals while the court considered the lawfulness of the government's conduct. But this court now sees fit to intervene, hastily dashing off a 4-paragraph per curium opinion, discarding the district court's order based solely on a new legal pronouncement that one might have thought would require significant deliberation. When this court decides complex and monumental issues, it typically allows the lower courts to address those matters first. That's what percolating. That's what that means by allowing these issues to percolate in the lower court. Hold on, I'm having a goddamn hot flash. About to say I'm having a heat stroke. That's what the fucking feel like. God damn it! Fuck you, menopause. Fuck you. Fuck you, Ronnie. Okay. I don't know if y'all know that movie reference. I'm not gonna tell y'all. You should go watch more movies. Okay. Okay, so she's now going to take some time to explain how the merits docket works, right? And I told you a little bit about that. But when this court decides complex and monumental issues, it typically allows the lower courts to address those matters first. It then receives full briefing, hears oral arguments, deliberates internally, and finally issues a reasoned opinion. Those standard processes may not always yield correct results, but when we deviate from them, the risk of error always substantially increases. Today's rushed conclusion that those challenging the government's action can only pursue their claims through habeas is Exhibit A. I lament that the court appears to have embarked on a new era of procedural variability. Oh, that's nasty. The word played and the word played. Do y'all know what that means? That means that they're making shit up as they go along. This is an artful way of saying that. That y'all making this shit up as you go along. Right? That's what she's saying. And it's dangerous. It's fucking dangerous. I'm gonna read that shit again. I lament that the court appears to have embarked on a new era of procedural variability. That means we can switch that shit up whenever it so fits us, and that it has done so in such a casual, inequitable, and in my view, inappropriate manner. I need you to find some stronger words, Judge Jackson. Inappropriate is too light. It's too light. At least when the court went off base in the past, it left a record of posterity. Oh, I remember. I did read some of it. It left a record so posterity could see how it went wrong. Oh, she cited Karamatsu. That's the case I was just telling y'all about, right? So we could go back and see how we got that wrong, right? And that's an acknowledgement that we got that so very wrong. With more and more of our most significant rulings taking place in the shadows of our emergency docket. Again, that's the shadow docket. And they right up in your face playing, they call it the shadow docket. Like, fuck you, we'll even tell you that we're doing this shit in the dark, surreptitiously. We'll even tell you, because you ain't even paying attention. You didn't even know there was more than one docket in the Supreme Court. Because you don't follow Ike Speaks. If you did, you would know. With more and more, okay, more and more. So because the shadow docket wasn't something that was used very often, but with time, right? We're seeing it used more and more and more. Oh, and the problem with that, she's saying, is that there is no briefing, there is no argument, there is no record of how the fuck we got here. I'm sorry. Okay, I got to read that again. With more and more of our most significant rulings taking place in the shadows of our emergency docket, today's court leaves less and less of a trace. But make no mistake, we are just as wrong now as we have been in the past, with similarly devastating consequences. It just seems we are now less willing to face it. Y'all, did you hear her? She said we was wrong then. We fucking wrong now. But at least back then we were willing to admit it. At least back then we were willing to acknowledge that we fucked up, that we made a mistake. Now we're not even willing to do that. And that's how she ended it. Oh, mic drop. Oh, that's how she ended it. We are just as wrong now as we have been in the past, with similarly devastating consequences. It just seems we are now less willing to face it. Y'all. Oh man, that's crazy. Whis, right? What's up, Keish? Yo, I appreciate y'all for hanging out with me and reading that decision. That was powerful. That was really powerful. The foreshadowing by Sotomayor, recognizing that this is just the beginning. This is just the beginning of what they want to do, right? And that there are mechanisms in place to make sure that this can be extended to not just Venezuelan citizens, but to anyone that the government might deem a threat, like Black Lives Matter. You know, Black Lives Matter, they could be seen as a threat to the government, right? They're not a nation, but neither is Tren de Aragua. It doesn't matter. And then summarily just ship your ass on off to CCOT, where hopefully somebody will see a photograph of you in some of the publications that are being released, so we'll know where the fuck you are. because otherwise they're not even trying to tell you where people are. Yes, this is wild. This is wicked. This is problematic. I will tell you, if you are not a U.S. citizen, you should not travel internationally. You will very likely have issues coming back. If you are not a U.S. citizen and you do travel internationally, do not take your phone. Do not take your phone. Get you a burner phone, get you a little bullshit throwaway phone, because if you have any social media, customs is going to go through your shit. If you're a citizen, don't take your phone because customs can go through your shit. Okay? And if they see something, if you're not a citizen, if they see something, they can use that as a basis to detain you. So if they see you posted some anti-Trump shit, well, you might be an enemy of the state now. So they're going to detain you, and I don't see this getting better. I don't see this getting better. I see this getting worse. And so the last thing, and I'll say before I cut out of here, is these policies have affected me personally. And bro, I don't know if you're still on here, but remember the dual citizenship that Dad was applying for? Yeah, Trump just deaded that. Trump just deaded that. I mean, not Trump. I'm so sorry. Italy. Italy just deaded that. So my great grandmother is Italian on my father's side, right? And so we were able to trace my dad's grandmother, grandfather, his great grandmother and great grandfather to Italy. We've got their immigration papers, we've got their naturalization papers. So we had everything that we needed to apply for citizenship in Italy, which was not very difficult because they recognized lineage, and you could use the fact that you are the ancestor, right? Grandparent, great grandparent, grandchild, great grandchild of a Italian citizen, and get citizenship that way. Just last week, Italy decided that they would no longer honor that, and immediately decided that they would stop granting dual citizenship. That shit is fucked up. It's just like, come on, man. I was on my way. What do you think about the phone searches that some are experienced going through customs? Yeah, don't take your phone. They have the right to do that. They have the right to search your phone, and they're looking to see what photographs you have. They're looking to see what social media you have. They're looking to see what you post. They're looking to see what you follow. They're looking to see what you like, because it doesn't even matter whether or not you are the one who's actually posting. But if you like something, right, then that might implicate that you have some sort of allegiance to some other government or entity or cause that might be anti-United States. They don't need much. And it's not like the custom agents are well versed in immigration law. They're not. They're not. That's what I'm hearing. I'm hearing lawyers who have had to get on the phone with customs officials and tell them what the law is, right? And some of them are receptive, but they don't have to be receptive to some lawyer on the phone who may or may not be a lawyer according to them, right? So they have the right to search a phone. Don't take that shit. Don't take it. You're on vacation any damn way. Leave your phone home. Leave your phone home. Any more questions? Any other questions? So we'll see what happens in the hearing today. It might already have happened. I'll update, and maybe I'll come back on Thursday or so, or maybe you know what I'll do? I'll talk about it on Thursday on Sirius XM. So check in, channel 126. I'm on from 8. Check out Dr. Greg Carr and Lamont King from 7 to 10, 7 a.m. to 10 a.m. I get on at 8. Join us, because I'm going to see what happened at the hearing today, and we'll see. We'll see if there's any lawsuits filed in wherever these people are actually detained now, and whether or not that's a habeas petition, and to see if they file habeas, and then the court says habeas is not the proper mechanism if you are not seeking release. Wouldn't that be a fucking stab in the neck? Like, what? You just told us that that was the proper mechanism. Now you tell. That's what she means by the procedural variability. That's a problem. Jurisprudence and stare decisis is a thing of the motherfucking past. Fascist America. Yeah, man. It's looking that way. It's looking a lot like, we're going down that road. Authoritarianism, dictatorship, fascism on the rise. And the parallels between now and Hitler's rise in Germany in the 30s, man, they're uncanny. Like the whole, just I'm not even gonna go into that. That's another video. That's a whole nother video. And my stomach is growling because I haven't had breakfast, and I did my workout this morning because I'm trying to get it back. Trying to get it. Trying to do. Okay, I'm out of here because I love you. I really do. I really do love you, and I do this so that we can be armed and we don't have to be at the mercy of journalists who don't know what the fuck they're talking about. It's your girl Ike here. I love you. I really do. Share the video so people can get educated. All right. Peace out, family.